Let's look at how privacy applies to certain regulations that we've already looked at. So for instance, HIPAA, privacy is very restrictive in the healthcare industry. We looked at the security rule earlier in the course, but HIPAA also has implemented a privacy rule. And it limits use and disclosure of protected health information which relates to an individual's physical or mental health or condition for health plans, healthcare providers, healthcare clearinghouses, and business associates. These are called covered entities. It only applies if the information identifies the individual and does not apply to de-identified information. That's important in research where information may be aggregated at a hospital or a healthcare provider and then included in a health study. The privacy rule allows covered entities to use and disclose protected health information to the individual for treatment, payment, or health care, incidental to the permitted use or disclosure, and for use in a facility directory, or to notify friends and family of the care. If the use or disclosure is in the public interest, it's as required by law for public health activities or regarding victims of abuse, neglect, or domestic violence, or for health oversight activities, law enforcement purposes, or for workers' compensation. If not covered explicitly by an exemption, the covered entity or business associate is required to obtain the individual's written authorization, specifically allowing use and allowing disclosure. And I don't know if you go to healthcare facilities very often, but it seems that like every other visit I go out there, they're having me sign additional paperwork on HIPAA privacy. So I assume that the healthcare provider is reviewing the privacy rules and regulations on a regular basis and updating their privacy notices appropriately. They should make reasonable effort to use or disclose the minimum necessary information. Minimum doesn't apply if the records are needed for treatment or disclosed to the individual or disclosed under an authorization by the individual. However, every healthcare provider must designate a privacy officer. One of the jobs of the privacy officer is to train all the employees on how to maintain privacy of HIPAA records. In addition, you need to implement all of the data security requirements that were under the HIPAA security rules. And it requires entities to provide consumers with adequate notice of the uses and disclosures of protected health information made by the covered entity, protecting the individual's rights, covered entities' legal duties with respect to protected health information, and written acknowledgement from the users. Gramm-Leach-Bliley was modified, or not modified, but within Gramm-Leach-Bliley, there are certain privacy rules that are also applied. Non-public financial data receives special protection. And where we looked at the security rules earlier, GLBA also has privacy requirements, which they call the privacy rule. It's less burdensome than the HIPAA requirements, but it does require two things: notice and choice. Notice is simply providing privacy notices at the time the relationship with an individual commences, and once a year thereafter. The notices have to be clear and conspicuous disclosure of the company's privacy practices and disclosure of any non-personal data to third parties, categories of persons to whom data may be disclosed, and the company's security policies. And choice allows users to choose whether to permit certain types of information sharing with non-affiliated third parties, such as those who are performing services for the institution or other purposes. And choice also takes effect in notifying the individual of intended sharing, and the individual then has the right to decide whether or not that sharing should take place. The California Financial Information Privacy Act imposes stricter privacy requirements on financial institutions. The California FIPA is codified to show that companies must receive opt-in consent from consumers prior to sharing their data with affiliated third parties. It requires companies to allow consumers to opt in, whereas with GLBA, companies are allowed to have customer opt-out capabilities. An opt-in, as you can imagine, requires explicit consent because you have to check the box or signify with a yes that you are allowing that opt-in capability. Restricts financial institutions' ability to share personal data with affiliated companies. So again, the customer must specifically provide an opt-out consent in that particular case. The CAN-SPAM Act increases the amount of junk mail. The CAN-SPAM app is fighting the increase in the amount of junk mail, particularly spam messages. I don't know if you really know how many spam messages hit a company on a regular basis, but in a company that I worked for recently, the number of spam messages were millions a week, literally millions of messages a week. And luckily we had mechanisms for filtering out spam messages so that very few got through to the employees. But it doesn't mean that the attackers aren't trying to get that information into us. It certainly when you see the statistics is quite an amazing number. So Congress passed the Controlling the Assault of Non-Solicited Pornography in Marketing Act 2003, CAN-SPAM. It's enforced by the FTC and the Federal Communications Commission, the FCC. And it's criticized in some corners because it preempts state laws and it prevents consumers from bringing private actions against spammers. So there's a prohibition of false or misleading transmission of information. Prevents senders of commercial email from sending false header information, such as email addresses and IP addresses. I'll show you an example of that in just a second. It must accurately reflect the identity of a protected computer used to initiate the message. The email headers can be a clue to the veracity of an email message, particularly since the CAN-SPAM Act has a provision prohibiting deceptive subject headings, return address or opt-outs, and identification of an email as an email advertisement. I have a couple of examples here. The first two are actually valid emails that came to me, neither of which was a in fact, actually, I believe these are both the same message. So this is all one message. It's a valid message. It was a valid advertisement campaign. In fact, I believe here you can see precedence is bulk. It's by a company called Levenger. And you can see in here the email address that was generated or where it was from. Now, importantly, you can see the subject here is a summer sale, fines under $100. It also looks at it has a very specific email address associated with it, and it has a reply to, which is very clear. It's going to Levenger and going to this campaign that they put together. You can see return path and reply to and the message all have very similar and very, it's all pointing to the same thing. If I look at a message which is clearly not a legitimate message, and I got this out of my junk folder. First thing that strikes you is there is no subject. But more importantly, you can look at just some of the anomalies. The reply to is Stella Morris 060@gmail.com, but you can see that they try to deceive you as saying this is from zenithcompensationhouse@gmail.com. If I remember correctly, this was some kind of a get some money scheme, but you can tell in this case that this is not a legitimate email that's being sent out to me.